Thank you so much. So first of all, let me thank you, Philip, for the invitation. I'm really, really honored to talk to you today and actually kind of close this wonderful colloquium that you had in this fall term. So after very, very stellar presentation, so I hope I will meet your expectations. Today is a very peculiar day because actually today the European institutions are currently discussing the AI Act, and it seems that today will be really the day where we will know whether the AI Act will go through or it will be halted, with many problems that we relate to this, because in June there will be the change of the parliament, the elections, and so that would mean if today they don't find a political agreement, that may mean that the AI Act, we will need to wait for much longer until a new parliament will take over the role. So today is really, really an important day, and obviously very compelling day also for this presentation today, where I'm going to present my research on the evolution of fundamental rights protection in the AI Act. So just in terms of a bit of structure of my talk today, I will start by giving a bit of context on what are the problems in terms of artificial intelligence, fundamental rights, and what are the key regulatory questions in this sense. Then I will show what I did for this paper, where I literally trace the evolution of fundamental rights in the EU AI Act. And then, of course, I will share with you some preliminary findings for this research. So before starting, I have two big disclaimers. The first is that I am a lawyer, and this is a paper that aims to target particularly legal scholars, even if I believe that researchers working on digital governance can be obviously very interested in this topic as well. And the second disclaimer is that, as I said earlier, we don't have an AI Act or yet. So they are discussing it. We are in a critical phase right now. So obviously what I'm presenting today is the first part of the research. So it's really a work in progress, which I have to continue doing after the AI Act we'll have a final version of the EU AI Act. So just to start, it is very hard, obviously, to summarize the relationship between artificial intelligence and fundamental rights. And so I thought that probably bringing a case could be the best way to summarize what are the key issues here. So if you're not familiar with this image, this is from the Amnesty International report called Xenophobic Machines, where basically in 2022, what happened was that the Dutch government resigned after a scandal involving basically the use of an automated system that the Dutch government was using basically to assess the risk that certain application for child benefits made by citizens in the Netherlands were basically a fraud or not. So they were using an automated system to do this risk assessment and identify potential fraudsters. And what happened then was that basically they discovered that the system was discriminatory by design. It was using nationality as a main criteria to determine whether a person could be a potential fraudster or not, and therefore basically targeting especially not Dutch national as fraudster. So of course, this gave rise to different concerns and led, as I said, the government to resign in 2022. So if we take this case, I think this is really an overview. What are the legal issues here? Obviously, we know that AI can infringe on many different rights. It's not just about data protection and privacy, but here we're talking about human dignity, non-discrimination, right to a fair trial, right to an effective remedy, and so on. So really a whole set of fundamental rights that are threatened by the use of AI. The biggest legal issue that has been researched extensively in the past year regards to the idea of opacity. Opacity as lack of transparency because certain information are kept secret by the providers, by the designers, Or opacity also has complexity because you need certain technical expertise to understand how these systems work. And in some cases, even designers don't really understand what's going on inside the machine, or the black box problem, as it has been termed in the literature. Other legal issues, obviously, the lack of remedies for an individual. If I have been discriminated against by an AI system, how can I have an effective remedies for this? Which obviously is linked to the lack of accountability and liability issues that the use of these systems raise. And more recently, I think the whole scholarship and general discourse on AI and fundamental rights has also focused a lot on the possibility that these AI systems can have adverse effects on workers, but also on the environment. If you think about ChatGPT, there has been research that's shown that every time you ask ChatGPT 1 to 5 questions, you consume basically half a liter of water. So obviously, huge environmental concerns there. So when we consider AI, fundamental rights, and regulation, basically we all agree that AI is a potential threat to fundamental rights. But the problem here from a fundamental rights perspective is that this threat comes from private parties, and this is called the horizontality problem. At the same time, however, states has a duty to protect fundamental rights, so this is part of their positive obligation, and therefore they need to basically regulate AI to prevent harm to fundamental rights. Regulation, however, is not so much of an easy solution. Obviously, there are problems there, or regulatory questions that need to be addressed. For instance, AI is always depicted as a kind of a trade-off between risks to fundamental rights, but also benefits. So how do you balance that? Obviously, another core regulatory dilemma is, on the one hand, we want to protect fundamental rights, but how can we do it without stifling innovation? And finally, obviously, how can we balance different fundamental rights and the protection of fundamental rights where there are also other interests here? For instance, the use of AI in the field of law enforcement is clearly an example of this. So when you use AI for pursuing a public interest, how do you balance that with, for example, transparency requirements and so on? So these are key questions, really, which now in 2023, basically worldwide, there are many initiatives on regulating AI. And right now, really, the question isn't whether AI would be regulated, but how. So just to give you a kind of idea of what's happening worldwide, this is a mapping of governmental or regional initiatives. We also have international initiatives, but this is just to give you an idea of different regulatory policy initiatives worldwide. And in this setting, obviously, the EU clearly stands out because they are attempting to provide a comprehensive legislation of AI. So it's not sector specific, but it's a regulation on AI more generally. So regarding the EU, which is precisely what I'm focusing on in this paper, the AI Act, obviously the focus on this specific AI Act it's justified in light of its relevance. As I said, it's the first country to propose a comprehensive regulation. It has a high content on fundamental rights, and obviously is a perfect case to test EU fundamental rights policymaking in the age of AI, but also the capability of the EU to provide a rights-driven regulatory model, to use the terminology by Anno Bradford. As I said, the AI Act was proposed in 2021. It's currently in the trilogue, but in the meantime, many events happened. So from 2021 till now, we have had the Dutch childcare benefit scandal. We have had the launch of ChatGPT, which highly influenced, for example, the vision of the parliament, which decided to introduce new provisions on foundational model and general purpose AI. We had many campaigns by civil society organizations that were arguing for enforcing and enhancing protection of fundamental rights in the AI Act. And of course, at the same time, we also had a lot of lobbying by big tech companies. And all of these events obviously profoundly shaped and influenced the AI Act. And really, what I observed when I was looking, obviously following closely the AI Act evolution, what I found very interesting were these two statements, one from the EU Commissioner and the other one from a member of the European Parliament. And I think if we just expose these two statements, we already have an idea of how this evolution took place. So on the one hand, you have the EU Commissioner, which in 2021 said, today's proposal aims to strengthen European position as a global hub of excellence in AI, from the lab to the market. So it's very market focused. Whereas on the other hand, in June 2023, when basically the rapporteur in charge of the AI Act in the European Parliament, when they had to vote on the amendments that they proposed, he said, we are writing history. We're shaping the global development of AI in the right direction with humankind and human interest at the very center. So you see the shift in focus here. And this is precisely the observation that kind of prompted this research for me. I'm trying to understand this evolution. So the questions I am to address is, how has fundamental rights protection evolved in the legislative process of the AI Act, and why? And I employ process tracing methodology to understand this evolution, focusing on the divergences between the approaches and their justifications, but also obviously on the compromises and on the compromises and the convergences that will take place after the trilogue, hopefully. And by doing this, the paper aims to shed light on the role of fundamental rights in the governance of AI, but also understand how the governance of AI actually influenced the approach to fundamental rights protection in the EU. So let's unpack a bit more the process, that I'm talking about here and that I'm studying. So the process is precisely the legislative process, looking into the actors. So right now we are in the first colored phase that you can see in red. We have obviously the Commission, which is the initiator of the legislative process, which gave this proposal in 2021. Then we have the Council and the Parliament, which are the two co-legislators in the EU. The Council basically released a general approach in October 2022, which is basically a document where they amended the proposal, and it aims to signal what is the political position of the Council to the Parliament. And then the Parliament in last June adopted amendments to the AI Act. So now all of these three institutions are having this interinstitutional dialogue in the trilogue, and we will see tomorrow morning what are the news on this. Below, you can see another very important actor, which is the European Data Protection Board and the European Data Protection Supervisor. These are independent supervisory authorities, institutions, which basically, among other tasks, they can also provide recommendations to the EU legislature when they are considering laws with a high content of data protection. So they're experts on data protection, and they release two opinions. The first one right after the proposal, and the second one right before the trilogue. And we will see in a moment how the role was actually very influential in shaping the views of the three institutions. So right now, obviously, what I'm presenting today with you, my preliminary findings regards to the first part of this process. And so I'm looking into basically these three institutions and how they are approaching these key questions of AI and fundamental rights protection and balancing with other interests and innovations. So what I did was basically to create really a comparative framework, trying to understand what were the key provisions here that deserved a very thorough and in-depth analysis. And I basically compared their three approaches using key questions. What role do fundamental rights have in this regulation? How are fundamental rights protected? And how is fundamental rights protection enforced? And my sources and data for these are obviously all the public official documents, which I have to say, the EU legislative process is quite easy to trace and do research on because everything is pretty transparent. But when, especially in the Council, not all the documents are available, so I was able to do successful information requests, which really allowed me to understand what is their vision and what is their political justification behind certain amendments. Obviously, also news. The AI Act was widely looked by media, in particular Euractiv, which is a source that I fully trust. And finally, these trilogue tables that are leading the discussion right now. So let's dig into this. After all of this introduction, let's see some findings. So before the trilogue, what happened is what I call the AI Act roller coaster. So what happened was that we start with a commission, which has a clear vision of AI. And I call their approach the AI market of values. So the idea is we use internal market legislation, AI is a product, and we regulate the market so that AI, which enters the market, is in compliance with certain requirements, which are part of our union values. Their proposal was actually highly criticized precisely for the lack of fundamental rights focus. So basically the individual that are the people that are impacted by AI systems had no rights, had no remedies. There was not even one reference to individuals that are impacted by AI systems. And it was widely criticized in the literature, civil society organizations, but also by the European Data Protection Supervisor, which gave an opinion and highly criticized the first proposal by the Commission for the lack of an explicit and strong focus on fundamental rights. But it was just the beginning, because from the Commission we got to the Council, and we really see a slippery slope down, what I call the trade-off approach of the Council. So what the Council did, surprisingly, I would say, because obviously the Council represents the interests of member states, the Council saw AI as a threat, but also as an opportunity, especially in the field of national security, law enforcement, and migration management. And so they really tried to carve out many exceptions to fundamental rights protection in this field. And we will go back to this in a second. This just to give a broader overview. Finally, we go up in this roller coaster with the Parliament. The Parliament did something absolutely incredible, in my opinion, because they really changed the nature of the AI Act. I turned the approach a human-centric AI because this is really the focus of their proposal. To me, it almost looks like a charter of AI and rights, in the sense that they really put humans at the center. They say that AI is a clear threat not only to fundamental rights, but also to the values of democracy, rule of law, and environment. There are general principles for AI. And finally, the individual has rights and remedies to protect and enforce their rights. So really interesting there. And I think from this process tracing, what I found was basically that the first opinion of the European Data Protection Supervisor was highly influential, especially in shaping the view of the Parliament, because basically the Parliament adopted most of the recommendation from the European Data Protection Supervisor fully, and few only partly, and really kind of shaped the AI Act towards, I would say, a very strong alignment with the General Data Protection Regulation, the GDPR. But let's unpack this a bit more. So what are the institutional approaches to fundamental rights protection? As I said, the Commission sees AI as a product, and therefore the appropriate regulatory response to that is market legislation. The Council, on the other hand, sees AI as a risk, but as a big opportunity in the field of law enforcement, and also sees regulation as a clear burden, not only for the AI software providers, but also for administrative authorities. And so they should basically regulate these only when strictly necessary. So what I found very interesting was that when I did this information request, I really highlighted certain justification. And just to read you one from Austria, they basically said, if we have to basically, as law enforcement authority, our law enforcement authorities have to consider their AI systems that are using for pursuing public interest as AI systems, so with all the administrative and regulatory burden there, then this system will basically be useless. So we cannot have regulation in that field. So very, very interesting vision, and of course, controversial from a fundamental rights perspective. And then finally, the parliament really sees AI as a threat to fundamental rights and other values. And the objective of the proposal is to promote the uptake of human-centric AI. So how do these three different institutions conceptualize fundamental rights protection and exceptions to these protections? So obviously the initial proposal and the real core of it is still there also in the later versions. The idea is, and this was quite groundbreaking in my opinion, was to say, well, there are certain AI systems that simply pose an acceptable risk to fundamental rights and therefore must be prohibited. So we have a list of prohibited AI systems. But then everything that is in between no risk and prohibited uses is considered as high risk. And these high risk AI systems have to be in compliance with certain requirements so that we can ensure that these risks are at least minimized, not eliminated, but minimized. And already in the proposal, we saw these many, many exceptions, but surely more balanced exceptions in the field of law enforcement and migration, because one of the pillars of the AI Act is also transparency. So there will be a database, there will be certain information that must be given with regard to high-risk AI systems. But we had already some exceptions in the field of law enforcement and migration. But when we look at the council, it's really incredible how much they carved out exceptions in this field. First of all, they excluded from the scope of the AI Act everything that concerns national security, which was not originally there. And they also really carved out all the guarantees that were present for AI in law enforcement and migration. When we look at the parliament, it's completely different. They added many AI systems to the list of prohibited uses. And they also proposed to prohibit EU companies that are operating in EU to export AI systems that are prohibited in the EU outside of the EU, which again was not present at the beginning. They also added general principles for all AI systems, and these principles are such as non-discrimination, fairness, transparency, and so on. And again, they also added new rules for general purpose AI, including the obligation for people that use AI systems to carry out a fundamental rights impact assessment. Regarding fundamental rights enforcement, as I said, the Commission has a very market-driven approach to this. So the idea was, obviously, the provider has the biggest role in here. So they have to comply with the requirements, and they have to certify this compliance with the requirement, with the conformity assessment procedure. And then once the system enters the market, then we would have market monitoring. But there was really no role for individuals there. The council is very similar, but there was a news, which was a tiny remedy for individuals. They could basically lodge a complaint before Market Surveillance Authority, which at the time didn't make much sense because Market Surveillance Authority have really no expertise on fundamental rights and on these issues. And that was very much changed in the parliament. So we still have this approach of the provider has a clear role, we have market monitoring and so on, but finally bottom-up approaches. We have two new rights for individuals, the right to have information about the system and the right to require an explanation when an AI system is used in decision-making, finally. And then we have remedies for individuals that can lodge a complaint with data protection authorities or even have judicial review of their decision before a court. So very different views here, very different and problematic, I would say, amendments made by the council. So we will see what will happen after the trilogue. This clearly will be key point of discussions, and obviously also the new rules on general purpose AI. So let's see tomorrow morning what will happen. To be continued, but also here what I think is important for us to look into is what are really the critical decisions for the governance of EU fundamental rights, and how the AI Act will actually impact the governance of fundamental rights in the EU. So first of all, which fundamental rights? And this is in green because basically all institutions kind of agree that we are not just talking about data protection anymore here. We are talking about all fundamental rights, and they should be EU fundamental rights. We are talking about the Charter of the fundamental rights of the European Union. So obviously this has both internal outreach between the European Union and member states, but obviously also an external outreach. Because what is clear from all of this tracing that I've done is that you really want to stand as a global actor in this sense, as an actor that protects fundamental rights. And obviously, this will also lead to some extent a shift in conceptualization from the governance of EU fundamental rights to the EU governance of fundamental rights in the age of AI. Another key point, and here we don't have agreement, we will see what will happen, but a key decision, in my opinion, for the protection of fundamental rights is what role do providers have and also individuals have in protecting fundamental rights when we consider AI. And so one approach will be the internal market legislation, so the Commission approach. And the other approach that probably will win will be the one of the Parliament, which is more related to this idea of indirect horizontal effect of fundamental rights with rights and remedies for individuals, which is surely more in line with the GDPR. The third key question here will be how to balance fundamental rights with other public interests. And this is the big clash will be between the Parliament idea and the Council idea. So we will have double standards of protection for AI in law enforcement and migration, and what will be the normative justification for that? Or we will go through with the Parliament proposal to add even higher standards of protection for AI in law enforcement and migration, precisely because those are very high risk areas where important rights are at stake. We will see what will happen, but obviously these will have an impact on fundamental rights protection in the EU. And finally, a key question for me is also who will interpret fundamental rights? The idea here is that the whole risk-based approach of the AI Act uses fundamental rights as a normative justification. They say AI systems are prohibited because it's an acceptable risk to fundamental rights. With high-risk AI systems, there is an assessment that is made. And the Commission proposal, this was automatic. So what the Commission said was, we determine when an AI system poses a high risk to fundamental rights. And here is the list. So the provider will have to go through the list and understand whether the system they want to develop is in the list and therefore in the regulation. This was the original approach of the Commission. So the interpretation of fundamental rights and the assessment of when an AI system poses a risk is done basically by the legislature. On the other hand, the Parliament and the Council amended this, and this is, in my opinion, one of the most dangerous loopholes in the AI Act version of the Council and of the Parliament, because they said, well, actually, no, it should be the provider to assess when the AI system poses a risk to fundamental rights. And of course, there are divergences between the Council and the Parliament. But what the Parliament said was basically, you look at the list of high-risk areas, but then you have to determine whether your specific system poses a risk. So in this sense, this requires that it's the provider that interprets and assesses whether AI poses a threat to fundamental rights. And obviously the answer to all of these questions will really, I think, determine whether the AI Act will be truthful to the initial promise of being a landmark legislation for the protection of fundamental rights. And all of these key governance choices will, in my opinion, also impact generally the governance of fundamental rights in the EU in the digital age. So obviously, this is just the first part, and I would like to thank you so much. We will see what will happen in trilogue. Stay tuned, and this will obviously continue. And yes, thank you so much again for the invitation, and I'm really looking forward to the discussion with you now.